this nation will rise up and live out the true meaning of its creed. We hold these truths to be self-evident, that all men are created equal. I have a dream that one day on the red hills of Georgia, the sons of former slaves and the sons of former slave owners will be able to sit down together at the table of brotherhood. I have a dream that one day, even the state of Mississippi, a state sweltering with the heat of injustice, sweltering with the heat of oppression, will be transformed into an oasis of freedom and justice. I have a dream that my 4 little children will one day live in a nation where they will not be judged by the color of their skin, but by the content of their character. I have a dream today I have a dream that one day down in Alabama, with its vicious racists, with its governor having his lips dripping with the words of interposition and nullification, one day right there in Alabama, little black boys and black girls will be able to join hands with little white boys and white girls as sisters and brothers. I have a dream today I have a dream that one day every valley shall be exalted, and every hill and mountain shall be made low. The rough places will be made plain, and the crooked places will be made straight. And the glory of the Lord shall be revealed, and all flesh shall see it together. This is our hope. This is a faith that I go back to the South with. With this faith, we will be able to hew out of the mountain of despair a stone of hope. With this faith, we will be able to transform the jangling discords of our nation into a beautiful symphony of brotherhood. With this faith, we will be able to work together, to pray together, to struggle together, to go to jail together, to stand up for freedom together, knowing that we will be free one day. This will be the day. This will be the day when all of God's children will be able to sing with new meaning, "My country, tears of thee. Sweet land of liberty, of thee I sing. Land where my fathers died, land of the pilgrim's pride. From every mountainside, let freedom ring. And if America is to be a great nation, this must be."
When the stakes are high, the debates get hotter. When the issues demand clarity, we bring the fire. Welcome to Crossfire. Crossfire, where politics meets perspective, where issues are dissected, and where no topic is off limits. From the corridors of power to the pulse of the streets, we break down the politics, the controversies, and the decisions that shape our nation. Join Dr. Tony Olisangbeki as he puts guests on the hot seat, drilling them with the tough questions, demanding the hard truths, and leaving no room for half measures. Get ready for fearless conversations and uncompromising analysis. Crossfire, exclusive on Odala 104.7 FM Onitsha, every Saturday from 9 a.m.
A very lovely morning to you and welcome to Crossfire on Udala 104.7 FM. This very beautiful Saturday morning, the second day in the month of May, the year 2026. Right here at Udala. And we are welcoming you once to the first edition in the month of May 2026. Wherever you are listening to us from and whatever you may be doing, it's always a pleasure to welcome you on this epochal gathering, epochal convergence. And it is a convergence of mind, convergence of intellectualism, convergence of truth, and convergence of everything good. That's why we are here to deliver the message and also to profess the truth. And remember, on this very platform, we speak the truth, we uphold the truth, and we preserve the truth. We call a spade a spade. We can never call a spade by any other name. That's more reason we say nos dicera veritas, nos dicera unison veritas, and nos dicera vivica cabit veritas, and nos dicera lingolum lingolum, and nos dicera contra lingolum lingolum. You are welcome wherever you are listening to us from. And for those of you listening from different parts of the world, we can hear you, we can really communicate with you. For those of you in Los Angeles, it's about 11 minutes down the hour of 1 a.m. over there. From those of you in Baltimore, United States of America, is in Maryland. It's about 11 minutes down the hour of 4 a.m. For those in China, it's about 11 minutes down the hour of 4 p.m. in China. And then the same applies to those in Japan. It's about 11 minutes down the hour of 5 p.m. in Japan. For those who we have in here in Africa, for those in Ghana, it's about 11 minutes and the hour of 8 a.m. in Ghana. Those in Brazil, 12 minutes and the hour of 5 a.m. in Sao Paulo, Brazil. And we've got so many other cities around the world covered, because what we do here, we ensure that the right thing is done at all times. You are welcome. Remember, it's a program we bring you nothing but the truth, undiluted as you may wish and as you may want it. My name is Tony Onlison Becky, the Honorable Speaker. Welcome you once again. And our focus this very morning will be on the Supreme Court ruling. Supreme Court delivered two separate rulings, and that was on Thursday. We discussed extensively about that yesterday, but we're going to have a different perspectives to the Supreme Court ruling. First, the ruling on PDP leadership, and at the same time that of ADC leadership, and also what it pertains to upcoming election and also primaries across different divides. And also we must let you know the attempts to deregister parties like Accord, Senate Labour Party, and also APP, even ADC as a political party. And we know very well the Forum of Former Legislators, they have approached this Federal High Court, but they joined the Attorney General as one of the defenders. But the Attorney General had earlier gone back to the court and then swear an affidavit to align with those who are seeking for deregistration of these political parties. You're welcome. Let's quickly bring you the political random stories, but do not forget that we're going to have a guest, and the guest will be joining us as we proceed on this very gathering, and as we proceed on this very occasion. We'll be having a guest who will be joining us, who will be speaking on the issue of the Supreme Court ruling and everything you should know about it. And also, let's quickly bring you the political random stories making round. Let's quickly do that. Once we are done with the political random stories, we will begin the conversation along the line. The guest will join us. You are welcome. President Bola Ahmed Tinubu will depart Abuja on Saturday on a three-nation visit to Kenya, Rwanda, and France. This was disclosed by Mr. Bayo Ononoga, Special Advisor to the President on Information and Strategy. And many Nigerians are talking, tongues are wagging. Why France all the time? Anytime Mr. President wants to make a visit, he will go to France. And then is he a visiting president each time? There's never a month or 2 months that the Mr. President will not make a visit. But this time around, he'll be visiting Kenya, Rwanda, and France. Bala Alawa, a nurse working at the General Hospital Kagara, the headquarters of Rafi local government area of Niger State, and 4 other farmers have been killed by terrorists. Weekend Trust also gathered that the terrorists launched an assault on Onguwan Karu village along the Alawa Pandogari road where Bala had reportedly gone to fetch firewood after closing from work at the General Hospital Kagara. President Bola Ahmed Tinubu on Friday assured the nation's workforce that his administration would not rest on his oars in tackling insecurity and poverty. The president gave the assurance during the 2026 Workers' Day celebration at Ego Square, Abuja, where he was represented by the Secretary to the Government of the Federation, Senator George Akume. Kano State Governor Abba Kabiru Yusuf on Friday ordered an investigation into the alleged deduction of 1.5 billion naira from workers' salaries by the former head of service, Abdullahi Musa. The governor issued a directive during the Workers' Day march past in Kano in response to concerns raised by the chairman of the Nigerian Labour Congress, Kano State Chapter, Kabiru Inuwa. Troops of the Joint Task Force, Northeast Operation Hardiness, have rescued 6 women and children abducted by suspected Boko Haram ISWAP terrorists in Ngoche village, Gwoza local government area of Borno State. The rescue was disclosed in a statement on Friday night, signed by the Media Information Officer, Headquarters Joint Task Force, Northeast, Operation Hardiness, Lieutenant Colonel Sani Oba. Governor Babajide Sanwo-Olu has approved a 50,000 naira wage award for public sector workers in Lagos State. The governor announced the award on Friday during the International Workers' Day celebration held at Mobalaji Johnson Arena. That means that Lagos workers have additional 50,000 naira to cushion the effect of economic hardship. It's just an award. It's not part of the salary. Former Adamawa State governorship candidate Senator Aisha Binani on Friday formally joined the Nigerian Democratic Congress (NDC), making her latest political move ahead of the 2027 election. Her defection comes 9 months after she left the ruling All Progressives Congress (APC) for the African Democratic Congress. Within 9 months, we've seen Aisha Binani move from different parties, starting from APC to ADC, from ADC back to NDC. A member of the House of Representatives, Lekki Abejide, has resigned from the African Democratic Congress (ADC), citing prolonged internal crisis, legal disputes, and leadership uncertainty within the party. Abejide, who represents Yaba East, Yaba West, Mopamu Road Federal Constituency of Kogi State, announced his decision on Friday while addressing journalists at his residence in Abuja. Remember, it was Lekki Abejide that Majabamila instructed, stay there, scatter them, cause confusion in ADC. But immediately the Supreme Court judgment came to his notice, he has decided to leave the party. The Nigerian Navy has imposed 13 hours of curfew from 5 a.m. to 6 p.m. on all maritime activities along the Calabar waterways as part of efforts to curb kidnapping and other criminal activities along Calabar or Run Channel. This is contained in a statement by Lieutenant Commander Suleiman Bala, spokesperson for the Nigerian Navy ship NNS Victory. A Nigerian streamer and entertainer Kata Efe made a winning boxing debut, securing a dominant 3-0 unanimous decision victory over controversial singer Portable in a match anticipated celebrating boxing showdown, and a bout which drew significant attention across social media. So Kata Efe take control from the opening round. And those were your news roundup or political roundup stories. We now move straight to the business of the day, and we go straight to what we have this very morning. Just as we announced earlier to you that we'll be having a guest who will be joining us, and the guest will join us along the line. But we're going to start by reviewing the Supreme Court ruling what transpired at the Supreme Court and the justices involved and what the judgment represents. Okay, we will be looking at this very judgment delivered on Thursday. Remember, in the case of PDP case, there was a split judgment, 3 against 2 when we face split judgment. Supreme Court, the maximum panel it can compose or it can constitute is 7. The minimum is 5. So it's usually at odd number to allow division. But when the case of PDP was corrupt and judgment was to be rendered, the panel had 5 members. Majority, 3 upheld nullification of a better convention on the part of PDP and they dismissed the appeal. And the 3 that upheld the nullification, you have Justice Chioma Egondu Nwosiheme. She was the one that read the lead judgment in one report. We also have Justice Muhammad Garubalawa and Justice Jonas Stephen Ade. These 3 were the one that dismissed Turaki-led faction appeal at the Supreme Court and aligned with the judgment of the Court of Appeal. And the 3 of them maintain that you cannot be indifferent of court ruling and approach the same court for justice. That there was a restraining order from the Federal High Court for you not to go on with that very convention. You went forth, you insisted and had a convention. Now you are before the court making prayers. You can disobey a court and come before a court. In fact, that was principally what their judgments stand for. Justice Chioma Egondu Nwosiheme, Justice Muhammad Lawa Garuba, and Justice Jonas Stephen Ada. These were the 3 that said you cannot disobey court order and come before court to seek for redress. But we have minority or dissenting judgment. They found that the Federal High Court, ab initio, had no jurisdiction to entertain the matter over the fact that it borders on the leadership of the party. It's just like somebody shouting infringement in football. Once an offside flag is raised, even if you were brought down by the opposition, it does not count because an offside flag has been raised. That's where the dissenting judgment comes from. That the offside flag was you don't have original jurisdiction. Whether you were disobeyed or not, that one will not count. Owing to the fact that ab initio, you had no jurisdiction. And the justices that held that, Justice Haruna Senami and Justice Abubakar Sadiq Umar, these were the 2 justices that said, of course, they upheld, in fact, they ruled in favor of Turaki-led faction. That ab initio, the Federal High Court, led by Justice Abdul Malik Joyce, had no jurisdiction to entertain the matter. So the order restraining the convention is nullity. It cannot count. I will ask you for a take on these two issues. I've used football to narrate the both. And just as we said earlier on, if you look at Justice Muhammad Garuba is from Zamfara State, I'm aware, and Justice Chiome Gondi Musiem is from Imo State, and Justice Jonas Stephen Ada, from look of things, is from Benue State. Okay. Justice Sanami, I'm aware, from Bauchi State. Justice Abubakar Sadiq, I'm aware, is from Northwest. I think Justice Abubakar Sadiq Umar is from Katsina State. All right, that's just about that. But the majority had their way. Yes, Justice Sadiq Abubakar Umar, and of course, Justice Haruna Sanami, they were in minority, they were just two. And you had other justices, they had their way. Of course, they should have their way because they were in the majority. Justice Chema Egundu Musinyeme, Justice Muhammad Lawa Garuba, and Justice Jonas Stephen Ade, they had their way. That you disobeyed court order and you can't just come here and ask for anything. Well, as the case may be, we will see to that. Our guest is already here, but I would want to ask you, because there's a way I want to do this. We're going to open the phone lines. I'm going to ask you your take. You're just going to make just a minute statement on what you think happened at the Supreme Court before we bring the expert analysis. We have in our studio this very morning Barrister Ugunadi. He's here to speak about this. Of course, he's a legal practitioner. He is a public affairs analyst, a public affairs commentator, somebody who is also aligned, but we're going to talk about his alignment later. But before now, let's quickly welcome Barrister Ugunadi. It's my pleasure to welcome you, Barrister Ugunadi.
Thank you. Good morning, Olita. Thank you. I'm sorry for coming rather late. Nature is nature. I overslept. Let me confess it.
Oh, you want to do confession?
Yes.
All right. I have to put on my stone and hear your confession and see if I can absorb you as a priest. But that's by the way. Let's quickly, open the phone lines and ask our listeners what to think about these explanations I've given about the development. We are talking about PDP case. We are not talking about ADC now. We are talking about the judgment coming from the Supreme Court on PDP case. We're going to talk about that now. Good morning, you're welcome. It's good to have you. Oh, so sorry about that. Good morning, you're welcome. It's good to have you.
Hello, good morning, Mr. Speaker.
Good morning, because I want the barrister to listen to opinions and then possibly can construct it very well. Good morning, you're welcome.
My speaker, for me, I'm not happy with the position of the judgment of PDP. It's almost like the judiciary that is joining hands to make sure that they destroy PDP totally. Okay, you let us to know that the suspension of they would at least let PDP to know that fine and good. Let them go and do a new Congress and elect the leader. Because what we are saying, we are always doing this. We say that the courts don't have right, don't have power to decide on the leadership of a political party. But it looks like we are the people that are doing that mistake. Because they are doing it. The court are doing it. Because if the court are not doing it, they will stand in the position of even the ADC and they remark them on issue. They would have said, let people go and settle your
All right, thank you so much. We said a minute.
That they have that judgment of that they mark their own part and obtained the authentic leadership. They would have given us a perspective of the PDP.
All right, we thank you so much. When we say a minute, we want to give you a teaser for us to begin the program, but you don't make it look as if you are having the all the time. Good morning, you're welcome. It's good to have you.
Monday Johnson.
You're welcome. It's good to have you.
Good morning, Tony, Mr. Speaker.
You're welcome.
I will want to say succinctly that it is not in tandem with the truth for Judiciary or Supreme Court in this case to choose a particular judgment to accept and the other to reject. Because these two courts that deliver judgment against and for is in the same rank. And the saying that you disobeyed, they disobeyed one and obeyed the other. So which one did they disobey and which one did they obey? Both courts are of ordinate jurisdiction. I was expecting that Supreme Court would have nullified both the convention held by Turaki and the one held by Wike and Co.
But the one held by Wike was not before the court. So can they act sumo motu?
That is exactly, I was thinking that Turaki, I think he said, Sam, you should have actually joined that case of Wike's convention in this very matter.
Okay, you meant he would have consolidated it by the time he was to, file his brief at the Supreme Court.
Exactly. Are you getting the point now?
Yeah.
To make it actually a case to argue for both the one held with Wike, by Wike. So that was a kind of mistake he made.
If he had done that and the Supreme Court says that it has nothing before it to dismiss that convention, that would have indirectly given Wike that authenticity he was actually looking for. Because you are thinking they made a mistake. If they had gone before the Supreme Court without having something tangible, something substantial, and the Supreme Court fails to rule in affirmation to their prayers, it would have indirectly given Wike the authenticity he may be looking for.
I was thinking, though I stand to be corrected, that when Wike, planned this convention they held, I was thinking that Turaki appealed against that convention before they held it.
Okay. All right.
So, are you getting the point now?
It's a matter before a lower court. So the Supreme Court couldn't have
even the one they ruled against and for was from the lower court.
You don't understand saying that the trial is still on, but the one they ruled for and against, the trial had been concluded by the lower court. So it came before them for.
However, Mr. Speaker.
Okay.
My final submission before I leave is that it's improper because Supreme Court is the highest court of the country.
All right, thank you so much because of time. All right, thank you so much. That's a teaser, and we can't go any further. Sorry if I picked their call. Let's bring our guest this very morning. I had to just open the phone lines for you to hear the minds of the people. We are talking about PDP. Maybe we're going to talk about ADC later, but let's begin with PDP. Of course, we saw where Supreme Court constituted 5-member panel, and there was a split judgment, 3 against 2. And we have looked at the 2 that felt that the Federal High Court ordinarily couldn't have entertained that very matter because it borders on the leadership of the party, which the Supreme Court had maintained over time that it is non-justiciable. But you had other 3 who said you cannot be in defiance to court order and come before a court, that there was a restraining order from a Federal High Court led by Justice Joyce Abdul-Malik for you not to hold that convention, that you did not satisfy the processes for the convention, like you didn't conduct state congresses and other things you did not do, and you rushed to a convention. For that reason, you cannot go on there. Go on and do the necessary thing. But they went and did what they did. But the 2 justices, of course, we have named them, they looked at the whole thing and felt that, you know what, since you don't have jurisdiction, that'd be an issue. Whether you were disobeyed or not, that wouldn't count. That's the judgment of Justice Mohammed Lawal Garuba, Justice Chioma Egon Dumosi Heme, and Justice Stephen Ada, where they thought that you cannot disobey court order and come before a court. But Justice Haruna Sanami and Justice Abubakar Sadiq Umar, two of them felt that you don't have jurisdiction. So whether you were disobeyed or not does not count, apart from other things they wrote. Let's get a thought, Barrister Ugunadi. You a legal practitioner, you a legal expert. Let's get a thought on some of these developments. Of course, you have listened to our listeners what they felt about the judgment.
You see, because one is not a lawyer, I will not blame the person for holding certain views of what the law does or what the court does. This impression, either rightly or wrongly, has been created that our judiciary is biased. That is not actually so. Now, there are two cardinal principles of law we are going to dwell on here. The first cardinal principle of law we are going to dwell on here is that a justice of a court, a judgment of a court must be obeyed, no matter how rascally made, until you set that judgment aside. No matter how stupid you feel the judgment is, no matter how rascally made you feel the judgment was made, no matter whether with or without jurisdiction, that judge, because it's a judgment,
it must be vacated.
It must be judgment before, and you is extant, you are bound to obey it until it is set aside. That is basic. Now, yes, the Supreme Court, the Electoral Act have made it clear that courts do not have jurisdiction into the domestic affairs of political parties. But the court have had jurisdiction, be it wrongly, and handed down a judgment. You are bound to obey that judgment. So the majority opinion of the Supreme Court and the dissenting opinion of the Supreme Court are predicated on two principles of law. The majority opinion is saying, look, you are in contempt of court order. You cannot be in contempt of court order down there and come up here to seek redress or come up here to seek justice, that you are bound to obey that one. The other two are saying, predicated on whether or not the court have jurisdiction ab initio. They are saying, look, because the court do not have jurisdiction ab initio, there is nothing for the court to talk about. Exactly. There are nothing before the court to talk about. But then these judgments are already given. And we should appreciate this about the judiciary and about judges. They are human beings. And they are entitled to their appreciation of the law. And they are entitled to take persuasion from lawyers. This lawyer will be arguing that 2 plus 2 is 4. The other one will be arguing that 2 plus 2 is 15. So it is for the judge to balance the arithmetic, looking at the law. But you don't stay in your house and say, oh, this order was made without jurisdiction, I will not obey it. You don't have that competence because it's a court of law, properly constituted. So that's the position.
So, but the point is, why do lower courts, especially the federal high courts, because when we call them lower courts, we are looking at from the perspective of the Supreme Court.
Yes.
Why do they always go into this matter when Supreme Court has repeatedly, say that they don't have jurisdiction, but if you look at Justice Abdul Malik Joyce, she is of the view that I'm not talking about jurisdiction or whether I'm not going to be the one that will determine your leaders. Follow the process. You have set out a process in your constitution. PDP constitution says that before a national convention will take place, there will be state congresses. But that was not done in some parts, and you rush to hold convention. And secondly, when you deny one of your own, the specs, to be part of the process, because
to even purchase form.
But then the argument was that he came late. There was a window for form purchase, and when the window was closed, he then came. That you cannot think of purchasing form at any time, at your whims and caprices. There is always a window. But that was argument they canvassed, but they could not canvass this argument logically before the court, and the court ruled that Sule Lamido be allowed to get involved in the chairmanship position of the PDP, and they did not allow him, and they went on to hold the convention. So where are we talking about? Of course, there was an Ibadan
convention,
high court, that ruled that the convention should go on. Now somebody made a statement. Which one was Supreme Court saying that they did not obey? That they obeyed one, because Ibadan High Court gave a ruling, a judgment. It was an order, not even a judgment. It was an order that the convention be conducted. Federal High Court Abuja, led by Justice Joyce Abdul Malik, gave a judgment that they should not go on with that convention. And they obeyed the one of a Federal High Court. And they believe it's a court of coded jurisdiction. But the Federal High Court came first. They went and procured a judgment, an order. Let me use the word order. They went and procured an order from a Federal High Court, mandating them to go on with the convention. At this point, Barrister Ogunnadi, what do we do?
You see, from your analysis, you have almost conferred jurisdiction on the courts, even though it's an electoral matter. Because for you to prevent a right of association, for you to prevent a party from enjoying his rights of association, takes it into fundamental human right. For you to prevent a party, a member who is interested, who is associating with the PDP members as a PDP member, for you to prevent him from purchasing from to contest that election, it now moves from election matter to fundamental right, because it is right to participate, to vote and to be voted for in that particular convention. So you take it out from the terrain of electoral right to the terrain of fundamental right. Now, in these judgments you are talking of, I like your language, procured. They went to them procured. Now, between the two judgments, which one came first? Which one is the first in time?
The Abuja own.
The Abuja own is the first in time.
Yes.
Then, and they are aware of the Abuja own. When they now went to Ibadan to procure the order. In developed time, whoever procured that Ibadan order is supposed to be in prison by now, because is an abuse of court process. As a matter of fact, the Ibadan court, if the Ibadan court was aware of the existence of that judgment, the Ibadan court couldn't have assumed jurisdiction, because what the Ibadan court actually did was to assume an appellate jurisdiction against the decision of a court of coordinate jurisdiction. What they could have done after the Abuja judgment was to appeal that decision of the Abuja
and apply for stay of execution.
Exactly, Abuja Federal High Court. That's what they could have done. There's what we do in the Federal High Court. There's what a process we file. You file a process called affidavit of non-multiplicity of suits. In that affidavit, you have to demonstrate that there is no suit on similar fact between similar parties in any other court. You have to also demonstrate if there has been a decision on that particular issue between the same parties in that your affidavit of non-multiplicity of suit. And why you have to reduce it into affidavit is that if such thing is discovered, if it is discovered that there was actually a suit pending some other place, if it is discovered that there was actually a decision made on this and you became before the court to abuse the process of the court, they can use that affidavit to charge you for perjury. That goes with 7 years imprisonment. But what we do here is that we shout our laws. We try to apply our laws when we think or when we are targeting a person. Otherwise, what played out in Ibadan within the realm of the judiciary calls for NJC sanction. That is my candidate position.
That's your candidate.
Exactly. If and only if that Ibadan court was aware on paper that there was a judgment, there is an existing judgment from Federal High Court Abuja of coordinate jurisdiction to the contrary.
You wouldn't say it's not aware or it wasn't aware because it was on dailies, it was everywhere.
Oh, no. Oh, no. That is why we get it wrong. Even if the judge was there when the judgment was made, the judge don't give evidence to himself. It is parties that give judges evidence. Judge cannot rely on what he read on newspaper or social media to say, I saw it in the Vanguard newspaper. I saw it in, I heard it in Udala radio. It must be an evidence before the court, such that a third party who never even knew what was happening, if he's handling that file, will know, oh, this was decision, this was this. It must be evident, it must be presented before the court. Even if the court is present when it is an event is happening, the court do not deduce evidence from because he was there. The evidence has to be presented to the court. So the court do not rely on dailies. Even if it's Vanguard, maybe print media, you have to actually tender to the court a certified copy of that particular newspaper. Even if you see the judge reading that particular newspaper, you must tender it before the judge certified.
So it's not a case of reading it over the newspaper.
No.
It must be presented before the court.
It must be presented before the court. It must be in the court file. It must be in the court file.
So that maybe may not have been done, and possibly you would judge it to be that the courts may not be in the know of such existence of the Abuja Federal High Court's judgment on this issue.
You see, what I cannot now get right is whether the Badojo order was made ex parte or made on notice. If it was made ex parte, it is extremely wrong. If it was made on notice, it means that they put the other faction on notice, and it is the duty of the other faction that obtained the Abuja judgment to now exhibit the Abuja judgment before the Bado court. And when that judgment is exhibited before the Bado court, well, the Bado court cannot sit on appeal against the decision of a court of coordinate jurisdiction.
But we've seen many times we've had courts of coordinate jurisdiction making opposing statements on different issues. So it's just, I think I've been able to find out now because it was Justice James Omotosho of the Federal High Court Abuja that actually went on with that. But of course, we saw what the restraint PDP for holding the convention, and then it was something he did. That was 31st of October 2025. Then, and the convention was to hold between around November 15 and November 16. But the High Court in Ibadan was approached and an order was got. And then if you look at that order, it came after
the
Justice Omotosho had given that order.
Yes.
And then if you go to, it was something Appeal Court decided because the convention later held. Then Appeal Court nullified the convention.
The Appeal Court was right.
On the disobedience of the court order.
Yes.
And declared the convention invalid.
Yes.
But then, on April 30, on Thursday, you have Justice Stephen Ade, who delivered the lead judgment. Of course, they voided that very convention.
Yes.
But then, you have dissenting judgment coming from Justice Sadiq Abubakar and then Salami, who felt, no, they don't have jurisdiction in the first instance. But you have explained that.
Now, let me tell you. You saw a dissenting judgment in any matter by an appellate court justice is not saying that, it's just saying that this is what I feel should be, but the majority judgment, even if it is wrong, prevails over dissenting judgment. You cannot in court go and cite a dissenting judgment to persuade a court. It has to be the majority judgment that prevails. So dissenting judgment, no matter how beautifully written, is still a dissenting judgment. I don't agree. That is the meaning. I don't agree with this position. We are judges of coordinate powers. You took this position in this matter. I'm taking this position in this matter. But okay, three is to two. The three prevails. You see, another area I want us to go to actually look at is, let us at times pity these judges. I'm very, very sorry. Some may be silly because I'm coming from the legal background. You see, judges can only act in what is presented before them, as I have said before.
Remember, let's also quickly point out before you go on. You're talking about judges acting on what is presented before them.
Yeah.
I just want to state this so that it will be very much clear. A Battle High Court led by Justice Laderon Akintola, what he did was to give an interim orders. He gave the interim orders permitting the PDP to proceed with his planned convention, and he gave that earlier on, and he also renewed the order because the order was interim, of course.
The ex parte.
Yes, he renewed the order on November 14th, allowed him to hold the convention on November 15th because the one he had issued before expired
by a flux of time.
Yes, and he renewed the order on November 14th to allow that to go on. So it was not a judgment; it was an interim order. But you have an order against judgment. Which one comes first?
No. An order, be it interim, be it interlocutory, is still an order of court. The difference between interim order, interlocutory order, and the judgment is that the judgments have decided the substantive issue with finality in that matter. While interim order is trying to say, please wait, it has passed within 7 days by a flux of time.
Yeah.
Interlocutory is trying to say, remain where you are. Let me decide the substantive matter. Then we arrive at a judgment. But the point is this. Because I'm a lawyer and know the consequences of discussing judges openly, whether it's a matter that has gone or a matter that is actually pending, there is a check on judges. and it is for the National Judicial Council to exercise their powers when a particular judge is reported to them via a petition. Look at what this man did. Look at the position. It is for their years to punish, not for us to be parroting it on the radio, on social media.
I asked you a question.
Media. Get back to the question.
Barrister Ugunnadi.
Yes.
You have an interim order permitting you to do something.
Yes.
You have a judgment saying you should not do it. Which one are you going to obey?
You are bound to obey both.
Which one are you going to obey?
An order is not inferior to a judgment.
Oh, an order is not inferior to a judgment. That's the point I'm trying to make.
Yes.
It has the same weight as a judgment.
Yes. The only difference is that the judgment is a final decision on the subject matter.
But which one will you obey, Justice Barrister Ugunnadi?
Between the...
You want to do something.
No.
You had an order saying go on and do it, and then there's a judgment saying you do not do it, being determined finally. Will you do anyone? What will you do in this position?
The question is this. Yeah. If there's a judgment forbidding me from doing something,
yes,
what I will do is
an order asking you to do it.
I'm coming. What I will do is to appeal it. I will not even go for a second order, for a opposing order. I won't even go because there's a judgment of court telling me don't do this. So I will not go to another court to pray the court. Let me do it. What I will do is that I will appeal that order that told me don't do it, and then I follow the appeal processes. There is no, the point I'm making now is that if I'm in that position, there is no point going to Ibadan to obtain an order while I'm aware of the existence of a high court order. Settled.
When
on the same matter.
Somebody had gone there to get such order without your knowledge, and you have seen that there is an order of high court from Ibadan asking you to do that. You were not the one that went and got it. Somebody went and did it for you, and without your knowledge, and you have an order before you asking you proceed.
No. I will obey the first in time judgment.
Oh, you obey?
Yes.
So there's something
because
is there anything like first in time judgment?
Yeah, of course there is. You just said it now. The judgment from Abuja is first in time to the order from.
It came in October.
To the order from Ibadan. So the moment I'm aware that there's a judgment on this matter, that I've told you on this subject matter, and you get an order from another court, that order did not mandate the faction. They went to the court to seek, give us an order to do
go
this.
on. That's it.
So what? As a matter of fact, they are in contempt of court. If I'm in the bench, if I'm in the panel of the Supreme Court that put the judge on that thing, I could have put all of them in prison.
How could you have done that? But it was not one of the issues brought before the court.
No. The courts, even the high courts can invoke his power, punitive powers.
But when they went to appeal courts,
yes.
When they went to appeal court, they did not bring the issue that they had an interim order. It was not something they brought up. They did not even bring it up before appeal court. They did not even bring it up before the Supreme Court. What they anchored their own appeal on was that a court that gave that order lacks jurisdiction. That's what they anchored it. So the court couldn't have gone to commit them to prison based on what you are saying because they did not bring that side before the court.
No. But I'm just presenting it. There is the certain judgment is predicated on two established positions of the law.
Yeah.
One, you cannot be in disobedience of a court order and come before us to.
No, yeah, you say the majority judgment. That's what judgment.
Exactly. The other one is predicated on look. This is party affair. We don't have jurisdiction.
There's nothing before us.
Now, what I'm trying to say is that both parties. I've not seen the CTC of the judgment.
Yeah, okay.
I've not seen the processes filed by both parties. But if the Supreme Court is aware that this judgment of Abuja is there, and the Supreme Court is aware that somebody went to Ibadan to procure. I take that language from you to procure an order. That person that procured that order from Ibadan is supposed to go to prison. That's what I'm trying to say.
Based on content, how would he go to prison? He
content.
Has every right to approach a court and then ask a court, give me permission to do what I want to do.
You have a right to approach a court, but you have to come with killing hands.
So you don't need to receive the court.
You don't just approach the court recklessly. That's the law. The law is a very beautiful.
But we've seen coordinate conflict judgments, conflict orders. Nobody has gone to prison.
The law is an established, beautiful thing. The only thing there is that in this time we abuse it. In the court recognize what is called abuse of court process.
Okay.
Abuse of court process is open-ended. What constitutes abuse of court process is open-ended. But I know very, very well that you cannot litigate on a matter already litigated upon within a court of coordinate jurisdiction. If you do that, it is an abuse of court process. In short, two matters cannot pen between the same parties, the same subject matter, seeking the same relief before two different courts of different jurisdiction. So what I'm trying to say, if I have to use that language, that order from Ibadan, interim order, is a lousy one.
A lousy one. Let me ask, if, because it's a game we keep playing and we can outwitted them, let's assume that they were having the feelings that they could be sued and possibly gone on to get an order which may be renewable, and later on maybe Federal High Court judgment comes later on, and they go on to do the convention, owing to the fact that the order for them to go on to do it had come before the judgment. Which one would they take? If they go on and do what the order says, they be in line with their maybe first in line.
First in time.
So if they had got such order earlier before the arrival of the Federal High Court judgment that tells them not to do it, the one that tells them to do it, and they went on to do it, they will be in compliance with what you call the first in time.
Let me take a little bit deeper. Because of the sensitive and fragile nature of political matters, the courts are very, very reluctant to grant ex parte application.
Okay.
The Supreme Court frowns at that. Courts are very, very reluctant to grant ex parte application. The court will always say, let me hear the other side, put them on notice. But that's why I use the language, with all due respect to the Ibadan High Court, that judgment was a lousy one. But like I said before, lousy or not lousy, you ought to obey it.
All right.
Now, the point is that the courts actually have to take themselves above the push from politicians. And that is why in the public eyes, people are seeing the judiciary as having been compromised. Otherwise, there is no way a court, because it's a court, will go ahead to make an interim order in a matter as sensitive as that.
Without putting the other party on notice.
Exactly, to hear from them.
And that's exactly,
because if the other party were put on notice, they could have presented the judgment from Abuja Court before him, and his hands will be tied.
All right. I understand that very clear.
It's lousy that such order could be made ex parte.
And if you are in the bench, you would have committed him, or those people that
No, let me tell you. The persons on the receiving side of that interim order ought to petition the National Judicial Council, and they deal with the judge according to law.
Later on, Akintola should be dealt with.
That's the proper.
He may not be in the, but your concern is that he couldn't have issued that interim order without asking the other party to
be on notice, because it's a very sensitive issue.
Okay.
You rarely obtain ex parte order from judges these days. You can, the type of ex parte order you can obtain from judges, maybe an order for substance service, maybe an order to enter a land that is in dispute to propose a survey plan. Those innocuous orders, these are orders that can be granted ex parte, or in situation of extreme urgency, where you demonstrate that life is at risk, where you demonstrate that there could be crisis, where you demonstrate that liberty is at risk. But we don't give ex parte order in sensitive issues that will touch on the life of a nation. I repeat, it's a lousy one.
A lousy one. All right, that's exactly what Justice Emekanwite did when Bala Nafiu Gombe approached him before his court, seeking to be recognized as the national chairman of ADC, asking the courts to compel INEC to de-recognize David Mark. Justice Emekanwite looked at his prayers and said, "No, what? Nafiu Gombe, put the other party on notice. Let them come and show cause. Why are we not granting
make this order?
prayers?"
That's
what Justice Emekanwite did.
That is it. You know, Joseph Kamite was here with us in Indonesia, so he was.
Oh, he was here.
Exactly. He got the basics of legal practice. So you cannot intimidate a judge of that exposure, with such experte, this experte, that experte. You cannot intimidate the person. I'm not saying that the judge in Ibadan was intimidated. I'm only saying that the judgment looked at, is a lousy one.
Okay. And then immediately Emeka Nwite made that very, very ruling that other party
be put on
notice. But David Mark felt that he has no jurisdiction in the first instance.
Exactly.
He has no jurisdiction. So what David Mark did was to actually rush to appeal court to appeal that ruling of Justice Emeka Nwite, where he demanded that Nafiu Balagombe put them on notice for him to decide the prayers before him. But David Mark and Arebochola, they felt that he has no jurisdiction to even make that ruling in the first instance. Of course, they were able to make a prayer before him that you have no jurisdiction, you have no this, and then he went further to commence trial without ruling on issue of jurisdiction. There are some reports that say that he said that that would be a consolidated ruling, that he would also look at all of them. Just file a brief. You find one on jurisdiction, you find one on issue that you don't need to be put on notice, you find a lot of things, and we consolidate all of this, but let the trial begin. They said no, the trial cannot begin.
Yes, jurisdiction is a threshold issue. The moment it is raised, you have to deal with it first before going. But
there are some judges that will tell you.
No, I'm coming.
Okay.
Because if you dive into it, and at the end of the day you find that you have no jurisdiction, you must have wasted what we call precious
time.
Judicial. No, just precious time. Precious judicial time. Because here that I'm still with you, we may be wasting time, but we are not wasting precious judicial time.
But it's too good, Daddy.
Yes.
Now, appeal court looked at the.
Well, let me also educate us the more.
Okay.
You know, most of these political cases, they are initiated by way of originating summons.
Yes.
And in originating summon matters, you don't go into the witness box to give evidence.
Yeah.
It's
about interpretation of the law.
Exactly. So a court still have the right to consolidate. Look, this is a preliminary objection challenging my jurisdiction. Bring it. Canvass your case as if I have jurisdiction. Canvass your case as if I have jurisdiction.
Okay.
In taking the decision, the court will first of all rule on the preliminary objection.
Okay.
If the court finds that it has no jurisdiction in the preliminary objection, the court will not go ahead to rule on the other one, because the court will say, oh, based on the objection, I wash off my hands and I want to file it, and it ends there. So a court can actually say, like Emeka Nwite did, consolidate whatever, bring your PO, bring your main argument, bring your counter to the PO, bring your main argument. I will look at it. I take the PO first. The court will read the PO. The moment the PO succeeds, the case ends there. The moment if the PO does not succeed, the court will now go into the matter. Okay. And the could be that the PO did not succeed. It doesn't mean that the person who brought the PO will lose in the main matter.
Okay.
That's it. Because jurisdiction belongs to the court.
So you are saying that Justice Emeka Nwite was right when he said consolidate everything.
Yes.
I will look them. I will look at the PO by the time I'm to make the ruling and also look at the substantive matter.
That is allowed in law.
But David,
because he never made an order impacting on the subject matter.
No.
He never made an order impacting on subject matter. He made a clever order. Oh, you want me to do this against these persons? It's all right. I will do it against them, but let them know that you want me to do this against them.
Yes.
That is the language of put them on notice.
But they said before when they were put on notice, these people came and canvassed that you have no jurisdiction.
Yeah, they have to canvass it. They have to actually canvass it for the court to rule on jurisdiction, because the court have not made any order that impact on either party. Yeah. Because they put them on notice. It is when they are not put on notice that they come and say, "Oh my lord, you don't have jurisdiction. This is a internal political party affair." It is now when the PO are taken, when arguments are taken, the court and then in the main substantive. The substantive suits are taken, that the court will now say, okay, let me take
that is exactly what happened. Let's quickly maybe fast track this, because Balagombe put David back on notice and they came and canvassed on issue of jurisdiction, and the court said, I'm going to consolidate everything. They said, no, you must rule on that first. You have no jurisdiction. The court says, I'm going to consolidate. And they said no, and they ran to appeal court.
What did that appeal? That the court did not rule on PO?
Yes, they went on appeal and then raised before the appeal court that the court did not rule on the PO, which he has which he has to Rufus. Appeal Court said, you can prematurely allow the court to make ruling for us so that we have something before us.
That is
there
it.
There is nothing before us.
That was why I was asking, what did that appeal?
Where the appeal court went and did his own magic was he raised the issue of status quo ante bellum. And when it came to the Supreme Court, because we are going to go back to the matter, the Supreme Court looked at the issue and said, appeal court, you were right because there was nothing before you. But you cannot have raised the issue of status quo ante bellum on nothing. That you cannot.
That there is this very famous case you say placing something on nothing.
Placing something on nothing.
The case of UAC and Mark 4 or Mark 4 and UAC.
Yes.
That's the notorious case.
Because the Supreme Court was saying their status quo ante bellum was on what? You said there was nothing before you, that they came prematurely, and you have nothing to rule on.
So why
did you invent the status quo ante bellum?
So where did you delve into? Why did you delve into that? And who raised it before you?
Who raised it? Because nobody raised that issue. Exactly. You went through
motu to. You see, that's why I say there is the human aspect in all that we do as man. That's the why. That's what the only thing I will say. There is the human aspect in all that we do as man.
Yeah,
that's the way I will like to end it.
You know, in the works of Justice Chukwudifu Oputa, in one of the judgments he rendered, he said, we are not infallible because we are final, but rather we are not final because we are infallible. But rather we are infallible because we are final. Now let's
made so by the constitution of the country, the ground norm. Exactly. Now that the case is that decision was made in AGOU and Damagum.
Yeah, exactly. Now the case now.
If you said the Supreme Court is a super court, its men are supermen. Continue. Let's.
All right. Let's really look at the jubilation by members of ADC. Immediately, the Supreme Court vacated that status quo ante bellum and made INEC to de-recognize David Mark leadership because it was what INEC acted upon, and then they interpreted their own status quo ante bellum to mean nobody having leadership, the party having no leadership. That's their own interpretation. Yes. But that has been vacated. But members of ADC, they have been jubilating. When I was talking with you yesterday on the phone, you said that it was a deceit. Of course, it was a trap. You called it a lot of things. Can you explain what you told me on the phone yesterday?
Now, let me first of all make it public that I belong to ADC.
Oh, you're a member of ADC?
Of course.
As a lawyer?
But I'm not talking as a member of ADC here.
You're talking as a lawyer?
I'm talking as a lawyer and also as a politician in my own small space.
Okay.
When that ruling, not even a judgment, when that ruling came, people were jubilating. People were calling me, barrister no mekwa. I say, what has mekwad?
No mekwa no, sir.
I say, what has mekwad? So I actually took my time to look at the situation, and I did I did put up some write-up advising my party and the public that this is a victory but not yet to Uhuru. The decision is this. Look, the substantive matter between you people are still fighting. Go back to the High Court and continue your fight. David Mark and Arigbe Shola, yes, at the face of it, you stand there. But the main case, substantive suit, is still happening at the Federal High Court. Go back there and fight it. And I looked at that judgment and laughed. And that ruling and laughed. Now, time is of the essence. And I was trying to think, if the court is running at the speed of light, and I don't think the court has the speed of light, I don't think the courts now can meet up. Because whoever loses at the High Court of first instance, will be tempted to go to the Court of Appeal. And the process of compiling a record, doing this, doing that, you cannot force the hands of the registry. Then whoever loses at the Appeal Court will be going back to the Supreme Court for final decision. Where is the time? And recall also that there is another judgment setting aside the convention of ADC. Setting aside the convention of ADC. Now, if ADC continue in their jubilation that look, the coast is clear, the coast is as dark as it was before, if not darker.
Oh, the coast for you is darker.
If not darker. I say it's as dark as it was before, if not darker. Because anybody risking to contest election in ADC in the circumstance, I use the language without reservation, it is just foolhardiness. The option I think is open to ADC is to see whether they can judge with Nephew Rabiu or Nephew Gombe.
Yeah, okay.
Nephew Gombe, if he has no external propeller, may yield to out-of-court settlement. But if he's being propelled from outside, if you like, bring back Jesus Christ, Nephew Gombe will never succumb to out-of-court judgment, because it's a suit deliberately actuated on achieving delay and on scattering ADC, and I believe they have reasonably succeeded. Some persons were arguing, oh, the Supreme Court did not exhaustively do what it was supposed to do. The Supreme Court could have invoked its powers under Section 22 of the Supreme Court rules. I say no. The Supreme Court cannot recklessly invoke its powers if you didn't ask for it. It's not a Father Christmas. The Supreme Court cannot just say, okay, on my own, I'm invoking this power. A party must ask the Supreme Court, please, because of time, invoke your powers under Section 22 of your rules and assume jurisdiction as a court of first instance in this matter and determine it with finality. That could have been a very beautiful submission from any of the camps. So that's my position on that.
Well, and you made a very startling and disturbing disclosure that for one to contest election under
ADC in the circumstance
is just 50-50.
Not 50-50. What I say is foolhardiness.
Foolhardiness.
Yes.
That implies that at the end of the day, if you lose the substantive matter, that election is forgone.
Exactly.
You will lose the election, and the second person,
not even losing the election, you are not qualified. And let me tell you what will happen. If ADC as it is now conduct primary election, take their list to INEC. This is the list of our candidates. INEC will say, oh, there's a court matter challenging your leadership. How far have you gone? And you have filed process in that matter. So you cannot say you are not aware of it. What INEC will just do is that in the space for candidates for ADC, they will say court. Court.
Oh, if any candidate they found, it will be court.
Of course.
And by the time court decides, it means that this candidate, if it court decides against them, means that they were not qualified for the election.
That's why I say that it is foolhardiness, not even 50-50. Foolhardiness. Taking extreme risk. I don't say that people should not take risk.
So you are calling for ADC to settle with Nephew Bala
if it is possible.
Because if these do not turn out, by then you may have been declared winner. But the court judgment may overturn your victory as not being qualified
in a pre-election matter.
In a pre-election, no, we're to just pre-election.
So it is foolhardiness. And I told you I belong to ADC. But there is we are trying to move. For me personally, if the movement is not possible, I will stay politically aloof for these 4 years. But coming to start jumping up and down, ADC this, ADC that. I mean,
no, you made it very clear that what the court just did was to allow you to be there. But while you are there, you can also be deemed not to have been a
go and finish what you have done there.
That's what it means. And then what it means that also that you may even within the time period, election may be conducted and you may be declared victory. Maybe at the senatorial,
just like the convention ADC conducted that was set aside.
Yes.
When they were going for that convention, I told some persons close to me, why is DC behaving as if there are no legal experts around them? This convention we are going for is not rooted on anything more. But because the court is says of the matter, let me not go far into that. But that convention, I had expected that it will be set aside. Ordinarily, my friends were agitated, this, that. I said, I'm not participating. I know the consequence of these things we are doing.
What? It's a very big insight you've given, Barrister Winari. That shows that you have a real depth and knowledge of law. We can't even call what happened at the Supreme Court on Thursday a Pyrrhic victory, because for you it's no victory. It's no victory. It means it was just a trap for you to continue the process where you don't know where it's going to land you.
I don't know where I'm going to land you, Bobby Trap. Maybe don't know where you're going to land. But the Supreme Court decided what is before them. They can't go.
They can't go beyond
exactly
what is before them.
If the team, either of the party have said, my lords of the Supreme Court, please invoke your powers under Section 22 of your rules and decide this case as a court first instance, because time is of the essence. This case would have been settled down.
You would have wanted the Supreme Court to assume original jurisdiction by the powers of their rule under Section 22 and decide this issue once and for all, so you know where you belong.
But not the Supreme Court coming to say, okay, we invoke it. They had the power to invoke it too. But it is better that a party canvass it before
they would have canvassed it.
Yes,
my Lord,
exactly. My Lord, time is of the essence. Look at this, assume you under Section 22 of your rules and decide this is the case of first instance. Then it will be settled finally, and Nafio Rabi, if he's winning, he wins. David Mike, that are winning, they win. It will be a clear course.
But if you look at the case before Justice Emeka Nwite, because that's the court that everybody's going back to right now, he has rulings to make. And if one of the rulings has to do with jurisdiction, let's assume that he assumed jurisdiction because he may feel that he's looking into processes not essentially issue of leadership. Let's assume we are not, because it's not also good to preempt court, but we are putting it under assumption, and maybe goes into the substantive matter, and possibly feels that Nafio, you are claiming the national chairman. You were not one. You said that you never resigned, but evidence before said that you resigned. He signed the resignation, and in fact, during the
inauguration, he was
there. The video evidence. So these were some of the things that ADC believed will be used to win the case. That he was there, evidence, everything points against him.
Let me tell you. Do you think Nafio Gombe does not know all this? Does not know that he will lose? He will lose and lose happily and go to the court of appeal. You don't stop him from going ahead. He will lose and lose happily. If you are playing along with him, that's where our stupidity lies. Nafio Gombe will lose and lose happily at the court below.
And go, and you will
he's achieving his aim of disorganizing you, of delaying you. While you are being disorganized, the time is tickling.
But what if he goes to appeal court and still lose there?
Supreme Court, goes from going to the Supreme Court.
And he goes there and lose too.
Of course, if you go there and lose to David Mark, will now have a stable. I'm coming. David Mark will now have a stable leadership administration, or it will now have a stable leadership with a comma. Because why I say with a comma is that there is still another high court judgment that set aside the convention.
No, the Congress. State congresses held.
Exactly, state congresses they were the convention. But the question now is, who submits name to INEC? It's the national body that submits name to INEC, not the state body.
Yes,
so if your mother is in the kitchen waiting for something to cook and their father has not come back, will the fire start burning? So if the national convention that brought in Mark and Aregbesola and the other national officers of ADC are still being challenged in court, and then the state congresses, some stand, some don't stand, the state congresses are as relevant as made by the national body, because it is the duty of the national body to submit names of candidates to INEC. So a state party chairman cannot jump and say, oh, because they are in court, let me bring this one. So if a state party chairman can even succeed in doing that, now who brings the name of the presidential candidate of the party?
You have canvassed very strong point, Barrister Ugunadi. The convention is challenged. Congresses challenge, leadership challenge.
So what a cage that we find ourselves inside. So the option there is either you jump out from the cage or you remain in the cage and suffer like one in a cage. And I don't think it is.
Is this a part of the one-party system? People have been saying that these things are being emanated from the ruling party, because we saw Femi Mwajabemila where he was telling Leke Abejide, who just left the party, because he needs to his name needs to be submitted by national chairman. Of course, he has none now. Where he was telling him scatter them, oppose them, and then the president, where he told some people that came to see him that one went to privatize a political party and one
and
said
they refuse.
No.
Exactly. And then my enemies want to remove security, and I refuse. Olisa, let me tell you, we are in a very big mess. It is not just all this is not just a move towards one-party state. It is a move towards monarchical one-party state. Monarchical one-party state. Now, before we used to have party primary election, indirect primary, but this time is consensus. One man will just stay in one hotel room and write the name of a would be member of a governor, it will be member of the House of Assembly, it will be a member of the National Assembly. The other day I saw online that Wike has presented to the president who will be the next governor of Rivers State. Is that not a dirty statement made by fools? The other day, this morning, I saw the governor of Lagos State, his deputy and president standing in their center, that Saul went to present the next governor of Lagos State to the president under APC. If you look at those things, will you not cry for our so-called democracy? We are descending into one-party state. And if we cannot fight them, and fight them well now, and get them down, it will be too bad by 2031.
You mean it will be very bad?
Not very bad, too bad by 2031. Because what they want to do this time, APC, is that they do not even want a contest. This is a party that have all the governors. This is a party that controls INEC. This is a party that controls everything. So why are you so afraid of being opposed? Why are you so afraid of contesting election? How does a president want to contest against himself? And how does a president come out and tell this man, you are not going for this one again. Stay back. This man will go. Is that democracy?
Okay. All right, let's quickly open the phone lines and then allow our listeners to come in. But we're going to go for a commercial break. When we come back, we continue with the conversation, but we're going to open the phone lines. We have Barrister Ugunadi, who is here, a legal practitioner, and also somebody who has very deep knowledge in matters of law. And of course, he has said everything you need to hear. Well, for him, Balagombe should be consulted and then ADC should find a way to settle with him. But there are those who are supporting Balagombe, giving him money, giving him that very push to continue, scatter them. I don't know, but he wasn't the one told to scatter them. It was Leke Abejide. But let's take a moment. We're going to just take some commercial, come back, and see how we hear from you. Please, I would want you to anchor your points, your submission on the position of knowledge, not emotion. You see the way Barrister Ugunadi was speaking based on knowledge, not based on affiliation and emotion. Like he was saying, he's a member of ADC, but he has to speak on the issue of law, fact, and what is before everyone. Let's take a moment. We'll be right back.
Udala Radio, 104.7 FM.
Searching for a place to eat good food and still enjoy premium relaxation? Stanley World Agwoka got you covered. Welcome to Stanley SFF Restaurant and Opriche Lounge Agwoka, where taste meets class. From hot, delicious local dishes to mouth-watering African and continental cuisines, pepper soup, grilled meat, rice, drinks, and many more. Everything is fresh and satisfying. Step into Opriche Lounge, a calm, classy environment to chill, hang out, and unwind. Perfect for friends, dates, and after work relaxation. Chop well, drink well, and feel cool morning, afternoon, and night. Stanley SFF Restaurant and Opriche Lounge, a haven for good food, great vibes, top security, and steady comfort. For further inquiry, call 0814-565-6920 or 0813-855-8009.
Quality bread, Wendy's bread, for your family breakfast. Wendy's bread, Wendy's bread, Mama, Papa, they like Wendy's bread, Wendy's bread, even children, they like Wendy's bread, Wendy's bread, Wendy's bread, you get it better, tasty, we go sweet your belly. Wendy's bread, Wendy's
Wendy's bread, tasty bread. You can contact us on our official address, Second Business Park, Enugu Road, GRA, beside CPS, Onitsha, Anambra State. We also have another branch at St. Michael Plaza, Atani Road. Also contact us on 070-1149-1571. Wendy's bread, your tasty bread.
Wendy's bread.
When the stakes are high, the debates get hotter. When the issues demand clarity, we bring the fire. Welcome to Crossfire. Crossfire, where politics meets perspective, where issues are dissected, and where no topic is off limits. From the corridors of power to the pulse of the streets, we break down the politics, the controversies, and the decisions that shape our nation. Join Dr. Tony Olisangbeki as he puts guests on the hot seat, drilling them with the tough questions, demanding the hard truths, and leaving no room for half measures. Get ready for fearless conversations and uncompromising analysis. Crossfire, exclusive on Odala 104.7 FM Onitsha, every Saturday from 9 a.m.
Nebek Real Estate brings you opportunity that grow with you. Greenfield Estate, Oba, just 1 minute from Owerri Road. Kings Court Estate, Ibiza, opposite Admiralty University. Purity Garden and Classic Estate, Asaba, just 10 minutes from Asaba International Airport. Ikenga Luxury Estate, Ojoto, 7 minutes to Electrical Dealers Market, Obosi. Nebek. Invest today, gain tomorrow. Visit us at 25 Oka Road, Onisha, beside Mandela, or Asaba Office 21 and 22, Brain Oil Mall, 295 ABC Road, opposite Lion House, Asaba, or call us on 080-3265-7455 or 070-1607-8648 or visit us at www.nebekgroup.com.
Yeah, welcome back. It's to Crossfire on Odala 104.7 FM on Nature this very beautiful Saturday morning. And we're about to take your calls. Remember, we still have in our studio Barrister Ugunade, who has given us his thoughts. He has read everything, and we were able to also extract one or two or many things from him as well. Of course, he says that what the Supreme Court did was to set a booby trap for ADC. And now it's a question of your leadership is challenged at the Federal High Court, your convention is challenged at the Federal High Court, some state congresses challenged at the Federal High Court. And these are pre-election matters. And most times, you may be almost there during election until judgment hits you. If it doesn't go your way, you've lost everything. Well, ADC, that's the way it is. Well, let's quickly allow you to come in because we just gave you a teaser before now, but we're going to just conclude that. 0803-221-6973 or 0803-827-6694. Please make it as brief as possible. Go to our Facebook. Please drop a comment. Of course, I'm going to take like 3 or 4 calls and I'm going to read comments on Facebook. I'm going to do this one because I won't forget again. And also, I'm going to ensure that those of you who are watching on YouTube also get some statements. Please make it there. Go to our Facebook at Odala FM. Just search Odala FM on Facebook. You'll be part of what we're doing here. Let's go straight to the phone lines. Good morning. You're welcome.
Good morning.
You're welcome. You are welcome. You are welcome.
My name is Mario Kechuka calling from Monisha.
Mario Kechuka, you are welcome. Please go on.
Well, to me,
Good morning. You're welcome.
My speaker,
you are welcome. Please go on.
My name is Honorable Basil Lugu, calling you from Monisha.
You're welcome, Honorable Basil Lugu. Please go on.
Barrister, good morning, sir.
Good morning, Bill Basil.
Okay, please, my question is, you are saying that is a trap for ADC. And my question now, what will you think that ADC would have done? Is it not better they accept this and rejoice for this one? When they reach the river, they will cross it. Because this is the first judgment, at least for them to recognize by INEC. And if INEC didn't recognize them in the first place, they won't do anything. But now the INEC has recognized them, they will have the opportunity at least to fill a candidate. And even if the candidate fail, they have tried what they're supposed to do. That means what they are rejoicing now, is it not good that they rejoice for the one they have? instead of waiting for the one they haven't seen.
All right, thank you so much. I know where Barrister Ogunadi is coming from. He's coming from the one you rejoice and be very happy with is the one that is permanent. You know, the way they sing it in our religious parlance, it shall be permanent, it shall be permanent. What the Lord has done for you, it shall be permanent. But what the Supreme Court has done is temporal. That's what Ogunadi is trying to say, that it's not permanent. Let's go back to the phone line. Good morning, you're welcome. It's good to have you. Hello, are you there, please? You are on. All right, I think he's not ready. Let's take another call. Good morning, you're welcome. It's good to have you. Okay, let's quickly do that. And there are many calls. Of course, if you're calling, be ready to know that your call has been picked. Not when you are calling, you'll be doing another thing. Good morning, you are welcome.
Good morning, my speaker, Tony Mbeke.
You are welcome.
Good morning, our guest.
Welcome. Good morning to you too.
I think the voice of Honorable Ignatius Okoye from Oration Kingdom.
You're welcome.
I guess I listened to you very well. It seems to me that you are knowledgeable about what we are doing, as Tony said. But I have one problem here. There is a statement you made that touches me so much about dictatorship, one-party system. Because you see what is happening now. Their president, when he was a governor in Lagos State, this is what he was doing. Remember Ambode? Remember, unless you raise your hand, he cannot be a governor of Lagos State. And now that he's trying to be the president of this country, all the senators are in his side. The judiciary in his side. Lower house in his side. Governors in this house of the whole state, that two states. What are we going to do? We are heading to a dangerous movement, situation in this country. Where what will happen in this country? Nobody will. People will baffle. Because if he continues like this, people are watching him. Some people are not happy. And if we have catastrophe in this country or opera, he will run away. The judiciary will run away. The legislature will run away. Even myself, I will run away. Then they will come. So I listen to what he said. I advise ADC, let them hold it suffering and challenge all those things challengeable before they move forward, before they are going. But I thank God that the ADC is now in the election, in the pilot, to be the pilot. Let us watch and see.
All right, thank you so much, Honorable Ignatius Okoye, for your submission.
Good morning, Mr. Speaker.
Good morning, you're welcome.
Yeah, good morning, our guest. I'm George.
Welcome,
Mr. Speaker, I would try to like our guest today because he almost spelled doom for ADC. But at the same time, we must understand the fact that this same court still didn't have the power to say tell Ayebe Shola and the mic to go back to the court to get the judgment there. At the end of the day, there will still be a disarray in the ADC about the leadership positions. But I think for now, they are out on relief. And I still believe that the ADC have the legal practitioner in their midst that will still go out there and dig every fact that will make them to succeed. So why they not rejoicing now and see what is going to happen at the end of the day? Which I strongly believe that they're going to see harder victory because APC may win the next election. APC may win the next election. But I strongly believe that with the way Nigeria is going, that they're still going to leave APC to compete with them. That's why we know that they may do one to or the other to make sure that they win. But I still believe strongly they will see the APC to still compete with them at the end of the day. So for me, the result people are just saying that this country has the power to organize them and let them to go back to the court and conclude the case there. But they give them the opportunity. So if anybody that is ADC member that is rejoicing, I believe that they see need and
before I finish the case. Thank you very much.
All right, thank you so much, Honorable George in the BC. Good morning, you're welcome. It's good to have you.
Yeah, Maroke Shuka, call back.
You're welcome, Maroke Shuka.
Thank you very much.
Okay,
well,
Chuka.
to me,
Maroke Shuka. Please go on.
yes, to me, all these legal gymnastics, honestly, it's just all to make ADC members to be afraid. Just a distraction. My barrister, I must tell the truth. If ADC will be like me, they will be very strong. Because all these court suits and all that court judgment, they are just to distract them. Just like the one of Bara Mohammed, I think. He has no case. He himself knows that he has no case. Now, on the case of the registering ADC, sorry, they know that ADC has won an election before in Lagos State. They are aware. Then on the one you talked about of High Court judgment that orders David Mark to stay away from the state executive. My brother, I want to ask, who if the national body did not recognize you, are you to be functional? That was a master, because I remember there was a time in Anambra State, NCC has a problem with their state executive, but the thing remains that the federal, the national chairman recognized one faction, and that faction was accepted. So to me, all these jumping up and down, we know where it's coming from, just to make sure that they are not together. So I'm urging them to be together. Forget all this nonsense. It's just a distraction to me. In as much as it is so pathetic how our judiciary that are supposed to be the hope of common man are the people dealing with us. They think that they are intelligent enough to be dealing with us. Now, see the Supreme Court themselves that say that no court has right to entertain any party leadership matter. That same issue was brought to you, and you failed to even listen to that, and you're sending them back. So that same issue, honestly, let our judiciary repent.
All right.
Stop being caught of confusion to this country. Thank you.
All right, thank you so much. But before then, let's also remind everyone, before you come in, let's also remind everyone that the Federal High Court ruling by Justice Joyce Abdul-Malik, it was on April 29, and where she restrained the Independent National Electoral Commission, INEC, from recognizing or participating in any state congresses conducted by committees appointed by David Mark-led Caretaker National Working Committee. Any state congress of ADC that David Mark appointed committee that will undertake them, INEC should not recognize it. She also held that Mark-led caretaker leadership lacks the legal authority to organize state congresses or appoint committees for that purpose. She also affirmed that the tenure of existing state working committees and state executive committees remains valid, subsisting until properly conducted congresses and a national convention held. So ruled that neither the Nigerian constitution nor the ADC own constitution empowers the caretaker or interim national leadership to override or sideline state executives in this way. It was on April 29 that judgment came? It was on Wednesday. But if you look at this judgment now, that means that even the state ADC Congress held in Anambra State is nullified in a way that, because INEC has been told not to recognize it. Look at what Justice Abdul-Malik. But her judgment borders on state congresses, that nothing coming from David Mark will be acceptable, recognized, or in any way.
And I think you should know the target. And let me come in. You see, people those are calling are saying, why am I quarreling with ADC jumping or ADC members rejoicing because of the judgment of the ruling? Look at it this way. One, before the Court of Appeal deleted the name of ADC leader from the portal, it was there was stability. It was when they say status quo from the Court of Appeal that they deleted it and they have now restored it. Yes, it's good. But you see, I don't think it is normal for a man whose wife delivered the stillbirth in the hospital to be rejoicing home carrying the corpse of the baby. So that's what this rejoice looks like. It's like going back from the hospital with your dead baby delivered stillborn, and you'll be rejoicing. What I'm trying to say is this. What I'm trying to demonstrate is this. Time is of the essence of these things that is happening. Had it been that these issues arose maybe sometime in April last year or March last year, for certain, for sure, that rejoice would worth it. And because I know that the case can drag to the Court of Appeal, to the Supreme Court, and started finally, and we see meet up with time. But we cannot meet up with time. What is short? That order is a bay order. We cannot meet up with time again, following the proper and normal legal processes. And there is no way Nafi Rabiu will not be challenging whatever decision the courts below makes. We are passing through the process of 3 courts before we get back to a final decision in that matter. Let me come in. There is one thing that should be of concern to me and you. We started discussing with PDP. We ended with ADC, peripherally, if I have to say. But all the persons calling in are discussing ADC. What does that tell you? The prime position of that political party. I'm not trying to campaign for ADC, because I said before about ADC, man. The prime position of that political party as a variable and veritable opposition to the party in power. And the party in power, those I don't call them leaders personally. I choose to call them occupiers of office. The occupiers of office today are fighting against Nigerians because they feel that Nigerians want power back to themselves through ADC.
All right. I want to ask you an important question. I understand the angle you are trying to go. The important question I want to ask you is this. When Justice Joyce Abdul Malik gave this judgment, INEC did not recognize David Mark.
Yes.
Because it was on 29th.
Yes.
She delivered her judgment. INEC at that point.
There was no David Mark in INEC.
There was no David Mark.
Yeah, yes.
So whatever she was saying David Mark led caretaker committee. And order. So what it means that since INEC did not recognize David Mark, and then the convention had based on the removal from Porter, but Supreme Court judgment came on a day later
and restored the
and INEC restored. So what does that Supreme Court judgment mean on Joyce Abdul Malik's judgment? Because from her judgment, she restrained David Mark led committee from having anything to do with the state congresses. In fact, remember,
and as at that time David Mark was not in the Porter.
And if you look around, the case was brought by one Norman Obinna and 6 others. They sued on behalf of the ADC state chairmen and their state executives. What that means that the congresses ADC had before doing the National Convention was invalidated by Justice Abdul Malik. And in invalidating that says that the ones existing should continue. It was judgment.
Yes.
What does that imply on the Supreme Court judgment? Because people are confused. Since Supreme Court
I'm not confused.
The Supreme Court technically restored David Mark. But when the judgment was given, David Mark was
not there.
And Abdul Malik gave a judgment on the fact before her that David Mark was not the national chairman. Of course, she said you cannot appoint this at the state levels to conduct congresses. It's a big problem, and this judgment must be vacated.
That is the problem.
Must be vacated.
No, that's why I'm saying we have issues in ADC. Whether you like it, I've said it before.
And if the state, hold on, let me continue before you conclude. If the state chairman went on, because they're not going to be the one that will sign the nomination, of course, if they were to be the one that will sign nomination, they will be doing that without even having
authority.
Yes,
but
they will not be. They are not going to be the one that will be signing of some of those things. So where does this take us? This judgment must be vacated.
I will not vacate it, must be set aside. That's what I said. That's why I said that there's a lot of bobby traps, there's a lot of confusion, and the judgment, no matter your view of that judgment, It remains a judgment. It remains a stand until set aside. Now, when do we have the time to do all this? If you say that, if you go to the Court of Appeal to set that judgment aside, they will follow you to the Court of Appeal and say, don't set it aside. If the Court of Appeal say, I set it aside, they will follow you to the Supreme Court and say, don't set it aside. They have people sponsoring there with money, and they are ready to do that. So, all I'm trying to say is this. That judgment of Dr. Abdul Malik was made when there is a temporal vacuum. A temporal vacuum because INEC did not put in the name of any other person in that position that David Mark was occupying. Exactly. So when now David Mark is restored to that position, the judgment traps him. Do you understand? The judgment traps him. Now, the Supreme Court judgment that brought David Mark's name into the portal. Let us differentiate between two things. Right. David Mark is the national chairman of the party. That his name was removed from the portal. What Supreme Court now did was to restore his name to the portal. Yeah. So, the moment his name is restored to the total, that judgment impacts on him. These were the analysis I did. Even if we try, because the ADC, majority of people in ADC rejoicing, do not even see this other judgment that came a day before the Supreme Court judgment. And this is a judgment moving in its own course. The one that was sent to the Court of Federal High Court, moving in its own course. So there are two cases now moving in the same course, chasing the same party, chasing the same main, and time is also running. How do we reconcile all this?
Remember, there is still a judgment that is yet to come on the convention itself. Ruling hasn't come on that one.
Exactly.
There are people challenging the convention itself. The doubt of Congress is perfectly challenged. And then the court ruled that giving that states Congress is valid. The people that were there, like if in Anambra State we have Maku Nwosu, who was elected, and we have Patrick Obianyo. So what the judgment is trying to say that Patrick Obianyo should continue, not Maku Nwosu. You can imagine that.
And you also, we are going for an election. You see, before I start jumping up to celebrate it, I have to analyze it. We are going for an election where you are the party chairman. 4 days ago, 3 days to the election, I become the party chairman, and then I will still work. I believe, and you believe that both of us will work in synergy to prosecute an election against an incumbent.
Disjointed.
I mean,
team
to prosecute an election against an incumbent.
And those who were there, we are of the view that, because don't you think ADC made a very big mistake? They could have returned all the incumbent state chairmen to avoid problem. At least scale this thing first.
Now,
they could have, because some of them that we are not restored were the ones that went to court.
Now let me tell you. You see ADC self, when God wants to act, he acts in a way. I wouldn't like to go into that. Okay. ADC self started from the word go to have a faction, pro article and the pro P2B.
Oh.
So that is the baseline.
Yes, I've been listening to Kenneth Okonkwo and Chegucho Wumi. The way they were, in fact, vomiting venom against against P2B and
Dele Momodu.
And you know, they have begun to fight within themselves.
And that faction started from the day one of the coalition. It started from the one of the coalition. Today they will tell you Atiku will step down. Today Atiku will come out and say, I'm not stepping down. The other day, Kenneth Okonkwo will come and start abusing P2B. Look at this other guy that is involved in concert. What is his name? These people that used to do concert, they call themselves Nollywood or what?
Okay.
This Edochie,
okay, no, he's not a member of a political party.
But you can hear his ranting.
But you know, his own is just a content creation.
You think he's a
content creator.
Exactly. You can hear his ranting. So what am I trying to say? All these things, faced with all this crisis, and faced with an incumbent government, and faced with the timing of primary election, and let me tell you, before you even go for primary election, you have to submit online your party register to INEC.
Yes.
So when will it?
Let me ask you. It seems that you have given up. Barrister Ogunnadi, I put it to you. You have given up.
I'm not giving up.
You are a member of ADC, but from the way you are speaking, you have given up already.
I'm being realistic.
You are being realistic, but you are giving up.
I'm not giving up. I'm being realistic. Then let me tell you. Yeah. If you have a cancerous growth and you say it's a boil, the cancer will continue to fester. And we'll be
so you prefer to call cancer a cancer as against calling it a boy?
I prefer to call a cancer cancer and call a boy a boy. Let me say it straight here.
Okay.
If I am one of the major decision makers, I wouldn't say in ADC. If I'm one of the, you've had obedient, from obedient to Obidati, from Obidati to Bikwa. Oh, P2B. If I'm one of the major decision makers in Obidati, in Obikwa, in Obidati, what we are supposed to do as supporters of P2B is to move as fast as possible and leave a house in disarray.
Okay,
let me say it openly.
Okay, you want them to
leave a house in disarray.
Look at Dati Baba Ahmed. INEC just recognized him yesterday as the national chairman of People's Redemption Party.
And I think he's moving towards it.
Yes, people are making some internal realignment.
Of course,
ADC seems to be a disaster waiting to explode.
So you have to look beyond. You have to look beyond the euphoria of what you are seeing.
And people are saying, P2B, you can come back to Labour Party. You have Nenadi Usman, but Nenadi Usman has ruled out that she is not going to. There's a way she said it. I don't want to really make mistake in paraphrasing her, but she was actually saying that they are going to fill the presidential candidate. Of course, INEC restored her as the national chairman or caretaker committee chairman of the party, and we have Oti, who seems to be in charge. Oti is in charge of Labour Party. Dati is in charge of People's Redemption Party. P2B's running mate in charge of a political party, and P2B's ally Oti in charge of a political party. P2B in a disarray of a political party called ADC.
So what are we doing there?
Coalition. Let's go and see if we can take another call and then wrap up. Good morning, you're welcome.
Yeah, good morning.
You're welcome.
I'm following your
Chibeze, you're welcome. You have to make it brief because we are running out of time.
Yeah. What happens? ADC has too much baggage.
You mean they have a lot of baggage?
A lot of baggage. So what happens is this, and I supported what this, and now from my inside source, Obi and Papa so are moving to NDC. NDC.
Okay.
Before Tuesday, everybody in the country will.
Okay, before Tuesday, Obi and the Kwankwaso will move to NDC.
Thank you for that information, and I celebrate it, and I assure you I'm moving with them.
Oh, you move with them?
Of course.
And you will remain in ADC.
What? If Obi leaves ADC, what's the means of ADC? If Obi leaves ADC
so
today,
are you encouraging Obi to leave ADC?
Seriously.
Let's allow him to finish. Go on.
Continue.
They're moving to NDC. I put the best thing. Don't be wasting their time there.
All right.
If Obi leaves ADC today, Nafi Gombe will withdraw the suits.
Oh, Nafi Gombe will withdraw the suits.
If Obi leaves ADC, now that I'm talking with you, in the next 30 minutes, all the suits must have been withdrawn. Obi said this and ABC is Obi.
Okay, that's what you think. But those that will disagree with you, Barrister Ugunari, those that will say, no, you are not. Good morning, you're welcome.
They're entitled to the opinion.
My name is Wanganga Wokoma, reaching you from Newi.
Quickly, Wanganga Wokoma, because we are completely out of time.
It is men that must do things that are difficult. Good thing always comes from a bitter pill. If you must cure malaria, you must take bitter pills. Nigerians have spoken. We are going to take powers from APC, whether they like it or not.
Amen.
They are sponsoring and using all that now to make sure that Nigerians not speak. We must speak. There must be a window. God lives in heaven. He sees what we are going through here. I will not give up like so many other Nigerians. P2B and his allies will attack themselves somewhere where they will contest this election and win. That is my own belief. Whether ADC, whether PRP, whether WBC, all we need as Nigerians is to gather together.
All right, thank you so much. Because of time, we have to let you go. Let me quickly appreciate those on our social media. I said earlier on, I'm going to read your comments, and I'm going to do that. We have this one coming from Wise GB Carter. He says, Good morning, Mr. Speaker and a guest, Honorable Jimmy Carter, representing Okpoko Federal Constituency. He went further to say, I want to ask, is NDC free? Or will INEC and Tinubu also go there and block them if P2B joins the party? Secondly, please, how true is this that some political parties will be delisted from contesting because they haven't won any seat in Senate? Okay, we're going to take that. Good morning. This one coming from Mazinwore Chikwadorum Osinachi. Good morning, my Honorable Speaker. He says, Chief Dr. Tony Olisambeki and our guests, I actually enjoy the wonderful program. Why is it that anytime Supreme Court makes a judgment, it normally brings controversial results and interpretations? Happy weekend. I'm watching live from Odabo on Nature. Of course, we have Okoye Angolika. Okoye Angolika says, good morning, beautiful souls in the studio. I'm Angolika, testing from Umoji. I love your program. We have Mordomo Dominic. Mordomo Dominic says, good evening from Japan. My people in house from Ahmadike Nobi. Thank you so much. Of course, keep it coming. There are other ones. Let's have your final segment. Because
Thank you.
We have another one to read, but let's have your segment while we...
It's all right.
Your final segment.
Now, my final segment is this. I appreciate Nigerians for appreciating their pains. You know, you can only try to wriggle out of a pain or a situation when you appreciate the impact of that situation on you. And I also appreciate the fact that Nigerians now recognize where their problem lies. I'm not trying to campaign. Please, Nigerians, I am pleading with us not to take this view of the judiciary very far. The courts acts based on what is presented before them. What is not before them is not before them. The Supreme Court, if they counsel to the parties before it in this ADC matter, had canvassed, invoke your original jurisdiction under section under order 22 of your rules and take this case as a case of first instance, it could have settled this matter with final and finality. But it does appear that was not canvassed. Let us appreciate the judgment of the Supreme Court from the angle that the Supreme Court decided on what was before them. And what that thing that the Supreme Court decided that was before them was very narrow. They decided you remove this man's name from the portal because status quo to Belum. Restore it. And nothing more than that. Then parties go back to the High Court and start, we are waiting for you when you come up again. And I'm trying to say that time is of the essence. APDC may not, in all honesty, pass through this process before the timetable catches up with them. And I also refer us to a case, another case, challenging convention that came up, the judgment came up a day before the Supreme Court judgment. And like Kolisa pointed out, there's also another case challenging jurisdiction, the convention. These are three cases running pari passu, challenging the same person. And this, it is not, even if the state Congresses stands, all the state Congress stands, who submits the name of the presidential candidate to INEC? Is it not the national body that do this submission? And we all know that Nigerians are running around P2B, not rallying around any political party. So I again call on Mr. P2B, as he prefers to be called, to leave ADC in disaster and take alternate moves. Nigerians are behind you. I am behind you. But in ADC, it is not. It's not possible.
Thank you so much. That's your opinion anyway. That's your personal view.
Personal, yes. Personal, yes.
Personal view. Because you're a member of ADC and you're also obedient movement.
I'm in obedient. I'm in Obidati. I'm in Obikwa. Anything Obi, I'm there.
Obidati has left, and then Obidati is in PRP.
That was the name we bought before. Anything that you see P2B, I presume that I'm there.
You better enter City Boy, because what is invoking City Boy? Everywhere we saw what the first lady did yesterday. 100 trucks of rice distributed across 19 northern states, and not just that. We saw, you know what that means? 100 trucks of rice. Distributed.
Olisabeki, I can afford to buy rice and stew.
No, 100 trucks A truck, do you know how many bags of rice a truck contains?
And I'm telling you, I can afford to buy rice.
First lady did it.
And listen, I'm an
people were there.
I'm an Osuka man. If I can't afford to buy rice, I eat Otipi. There's this local Osuka food that is called Otipi, and it's very cheap.
All right, thank you so much. That's all we have for you this very morning on Crossfire on the 104.7 FM. Of course, we appreciate all of you. Those who made their comments on Facebook, time it will not permit us to complete enough time. Thank you so much, Barrister Ugun Nadi, for your time.
Thank you, sir, for the opportunity given to me to speak to people.
All right, thank you so much, our people. Enjoy your weekend. Definitely have to go straight to the Rector Summit. That's the next event I have this very morning. Thank you so much for your time. My name is Tony Listen Becky. You have a wonderful weekend. Remember the next program, Sports Arena with Prestige. We're gonna just take you on that. Do not go anywhere.
Udala Radio 104.7 FM.